Namaste, good afternoon, and welcome. I think few of you already know me. My name is CS Rajesh, practicing company secretary, BCom graduate, and a law graduate. Teaching experience, it's been almost 7 years. I'm into teaching. I teach law for Foundation, Inter, as well as a final CA Foundation, CMA Foundation, and CS Foundation, CMA Inter, CA Inter, as well as CMA final. So I will be handling law for you guys. So there is certain changes in your law syllabus. If you have gone through the syllabus, they have made certain changes. Let me go through the syllabus first. Yeah. This is your material. Yes. So the entire law is for 100 marks, which consists of commercial laws for 30 marks, and industrial laws 15 marks, and corporate laws 40 marks. So it has a good weightage in your new syllabus. So in total, the entire law is for 100 marks, which also includes ethics and emotional intelligence. There are few new chapters which are included in the new syllabus, that is introduction to law and legal system in India, which is nothing but the Constitution of India. Few fundamental rights are included, and also they've included how the laws are made in India and what is the legal system or jurisprudence of India. Along with that, we have Indian Contract Act, which has a weightage of 10%, that is 10 marks. Then Sale of Goods Act 5%, Negotiable Instrument Act 5%, Indian Partnership Act and Limited Liability Partnership Act, which is both consist of 5%, that is 5 marks. Then we have industrial laws, which has a weightage of 15 marks, and corporate laws has a weightage of 40 marks. So in today's class, we'll directly start with the Indian Contract Act 1872, which has a weightage of 10 marks in the new syllabus. Okay, so let's start with the Indian Contract Act 1872, the mother of all the laws, or one of the important laws which each and every professional student studies, whether it is CMA or CA or CS. All the students study this chapter called Indian Contract Act 1872. So the chapter name is the Indian Contract Act. Indian Contract Act 1872. This is the chapter name, the Indian Contract Act 1872. So this entire act is divided into 4 parts. It is divided into 4 parts. Section number 1 to 75, first part. Section number 76 to 123, second part. Section number 124 to 238, the third part. And section number 239 to 266 is the last part. So the entire Indian Contract Act is divided into 4 parts. The first part is section number 1 to 75. Section number 1 to 75 deals with general principles of contract. The general principles of a contract. Principles of the contract. Section number 1 to 75. Section number 76 to 123 used to deal with a contract of a sale. A contract of sale of goods. Section number 76 to 123 used to cover or govern the topics with respect to contract of sale of goods. But in the year 1930, section number 76 to 123 were removed from the Indian Contract Act, and a separate law is made, or a separate law was made, called as Sale of Goods Act in 1930. So in the year 1930, 76 to 123 were repealed. We call it as repealed from the Indian Contract Act, and a separate law was made called as Sale of Goods Act 1930. Then we have section number 124 to 238, which deals with special contracts. Special contracts. So there are 5 special contracts which are covered under section number 124 to 238. What are they, sir? The first one is the contract of indemnity. Contract of indemnity. Contract of indemnity. Second one is the contract of bailment. The contract of a guarantee. Contract of guarantee. Then we have contract of bailment. Contract of bailment. Then we have the contract of pledge. Contract of pledge. And then we have the contract of agency. Contract of agency. So these are the 5 special contracts which are covered under section number 124 to 238. Then we had section number 239 to 266, the fourth part. The fourth part is to deal with the contracts of partnership. The contracts of partnership. So the provision with respect to partnership agreements were covered under section number 239 to 266. But these section numbers were removed. They were repealed from the Indian Contract Act 1872, and they made a separate law called as the Indian Partnership Act and 1932. In which year? 1932. So at present in the Indian Contract Act we have section number 1 to 75 and 124 to 238. So the remaining section numbers were removed or repealed from the Indian Contract Act, and there are separate laws to govern sale of goods contract as well as sale contract of partnership. So at present 1 to 75 deals with general principles of contract, and 124 to 238 deals with special contracts. So both section number 175, 1 to 75 and 124 to 238 is there in your syllabus for 10 marks. So we have to study general principles as well as the special contracts. Sir, we know what are special contracts. What we gonna study in the general principles of contracts, sir? Simple. We have to remember an acronym. We just have to remember an acronym called IOC. CFL, a VP, a DB. This is the acronym which you are required to remember the topics of general principles of contract. So what we're going to study in general principles of contract? First of all, introductions, where we will study the basic concepts of contract. Then we'll study about offer and acceptance. Offer and acceptance. So once it is done, we will discuss about considerations. After that, we will discuss about capacity to contract or competent to contract. Then we will discuss about F. F means the free consent. Then L. L means lawful object and consideration. Then we have V. V means void agreement. Void agreements. Then we have P. P means performance of contract, contractual obligations. Then we have D. D means a discharge of contract, and B means the breach of contract. So our Contract Act starts with introduction, and it covers section number 75 till breach of contract. After that, we have to discuss this special contract called contract of indemnity, guarantee, bailment, pledge and agency. So this is the structure of Indian Contract Act 1872, which consists of 10 marks for your examinations. Okay, so Indian Contract Act 1872. So before I get into this chapter, or before I start discussing the topics of this Indian Contract Act 1872, I want you guys to know or understand few basic concepts of law. What are those basic concepts of law, sir? The basic concepts of law which everyone should know, or which is also included in your syllabus, is first question: what is a law? What is a law? The first question is, what is a law? What is a law? One second. What is a law? This is the first question which you should be able to answer to understand the law topics. Second question is, who makes the law in India? Who makes the law in India? The third question is, how the law is made? How it is made? So these are the three questions which you should be able to answer before we start discussing this Indian Contract Act 1872. And also the fourth question is, or the fourth thing is, how to read sections. How to read sections of the Indian Contract Act 1872. So first one. So what is law? Law is nothing but it includes act, rules, regulations, then it also includes the precedents, nothing but judgments of the court, and also includes ordinance passed by the government. It also includes even the customs which are practiced in the society over a period of time. So all these are considered as what? Considered as a law. What is the first one? Act. Now what is act, sir? A law made by the legislatures, the lawmakers in the parliament or the legislative assemblies is called as act. For example, we have Companies Act, we have Contract Act, we have GST Act. That is a law which is made by the legislatures after passing a bill in the parliament or respective houses. Then we have a rules. Within the act delegates certain powers to the executives to make the rules within the purview of the law. That is called as rules. For example, MCA makes rules, that is called as companies rules. Companies rules. So MCA is a executive. In the same way, we have CBDT, Central Board of Direct Taxes. It also makes what? Income tax rules, IT rules. So when an executive, that is the department of the government, makes the rule within the boundary or scope of the law, they are called as rules. So law includes act as well as rules. It also includes regulations. So now what are regulations? Regulations are made by self-regulating body. Self-regulating bodies are self-governing authorities like RBI, like SEBI. So these are the authorities or monitoring agencies or institutions who can make regulations. For example, ICAI makes regulations, ICSI make regulations, ICMA makes regulations for its members. So when a self-governing body makes certain rules, it is called as what? Regulations. So law includes act, rules, regulations. It also includes precedents. So what are precedents, sir? The judgments of the court, the judgments of the higher courts, which are required or bound to be followed by the lower courts in a similar cases, are called as precedents. For example, if Supreme Court decides a case in a particular way, the same principle should be applied in the all high courts. They can't overturn the decision of the Supreme Court. That is called as precedents. So precedents becomes a rule of law which is required to be followed in the similar cases. That is why precedents are called as law. Then comes ordinance. So who makes ordinance? Ordinances are made by president. The ordinance is promulgated either by the president and also by governor, the governor of the state. In case of central law, it is president. In case of state law, it is the governor. So when the parliament is not in session and if the government is in need of making any urgent laws, they can adopt the route of making the law through the ordinance. They can recommend to the president to make an ordinance which becomes a law. And customs, even the customs which are practiced again and again in a particular way are considered as a laws. For example, our Hindu law, Hindu Marriage Act, Succession Act, then Inheritance Act, Adoption of Children's, and Guardians and Wards Act. All these are based upon our customs which are practiced over a period of time again and again. So the law includes act, rules, regulations, precedents, ordinances, as well as customs. All these are considered as a law. And this is the definition which is given in the Constitution of India under Article 13, which I will discuss in the chapter number 1 when I discuss the chapter number 1. So as per Constitution, law means and includes act, rules, regulations, precedents, ordinance, and customs. I hope you guys understood the difference between the word act, rules, regulations, precedents, ordinances, as well as customs. Yes. If you guys have any queries, you can drop a text in the chat box so that I'll get to know if you have any doubts or questions. Okay. Yes. Then second question, who makes the law in India? Who makes the law in India? I already gave an hint. The laws are made by whom? Legislatures. Now who are legislatures, sir? The elected representatives of the people are called as legislatures. For example, MPs, MLAs, they are called as what? Legislatures. In case of central laws, we have the parliament, which is called as legislatures, and we have a bicameral system of parliament. Now what is bicameral system of parliament, sir? Means we have two houses. One is a Lok Sabha, one is Rajya Sabha. So both together constitute or forms the parliament in India, and a bill is required to be passed in both the houses to become a law. So who makes the law? Legislatures are the one who makes a law in India. So the third question, how it is made? Obviously the law making process starts with what? Starts with drafting of bill, drafting of rules. So we have a separate commission for this called as Law Commission of India. So the Law Commission of India, sir, what does Law Commission does, sir? This Law Commission identify the areas in which a new law has to be made or amendment is to be carried out. So once it identify the areas in which a new law has to be made or amendment is to be carried out, it drafts the rules, and these drafted rules are presented to whom? Presented to the cabinet. Now what is cabinet, sir? Nothing but Council of Ministers. And when I say government, it is a Council of Minister which is headed by the Prime Minister. It is called as government. So there will be a cabinet with all important ministries which is headed by the Prime Ministers. So this bill is presented, not bill, the rules are presented to the cabinet, and once the cabinet gives the approval, to the draft rules or proposed rules, it becomes a bill. It becomes what? A bill. So the bill is ready. So once the bill is ready, the law making process starts. So once the bill is ready, as I said, because we have a bicameral system of parliament, the bill is introduced where? A Lok Sabha, the lower house. So in Lok Sabha, what happens, sir? There will be discussions, there will be arguments, then the bill is presented for voting by the members. So there will be discussions among the ruling party members as well as opposition party members. There will be arguments among them, and then the bill is presented for voting by the members. If the bill secures a majority of the vote in the parliament, that is Lok Sabha, it is passed in Lok Sabha, then it goes to where? Rajya Sabha. Again, what happens in Rajya Sabha, sir? Same thing will repeat. What are the same thing? There will be discussions, there will be arguments, and then bill is presented for voting by the members. So once the bill passes or the bill is passed in the Rajya Sabha with a required majority, it goes to the president for his assent. President for what is assent, for his approval. So once the president gives the assent, that is called as an act, a law that becomes an act. Till that stage it is called as a bill, and once the bill is ready and once it is passed in Lok Sabha, Rajya Sabha and signed by the president, it becomes an act. And what it is called as? Act. It can be Companies Act, GST Act, Income Tax Act. This is how the laws are made in India. And this act will be notified by whom? By the government. It has to be notified by the government. Where? In the official gazette. What gazette? Official gazette. Official gazette of the government. So we have the official gazette. It should be notified in the official gazette. So once it is notified in the official gazette, it becomes applicable to the people of India, and everyone must follow it, whether they like it or not. So this is how what is made? The laws are made in India. Okay. It starts with the drafting of rules. Once draft is ready, it is presented to the cabinet. Then cabinet gives the approval. It becomes a bill. It goes to Lok Sabha. There will be discussions, argument and pass. Then it goes to the Rajya Sabha, where there will be discussions, argument and pass. Then it goes to the president for his assent, and once the president gives the assent, it becomes an act which is applicable to the people of India. So we got the answer for the third question also, how it is made. The first question is, what is law? Act, rules, regulations, bylaws, and also the precedents and ordinances. Why? Who makes it? Legislatures, lawmakers. How it is made? We discussed the procedure to make the law in India, and how to read section numbers. So in law, for each rule or each provision, there will be a number assigned to it. The numbers assigned to the provisions of the law are called as sections. How to read section numbers? Section numbers always starts with, for example, let's say if I write like this, 341A. How to read this, sir? The first one is called as what? Section. The first number is called as section. Second is called as what? Subsection. Subsection. This is called as what? Clause. And this is called as what? Subclause. Sir, how to read this, sir? Please tell how to read this. First number. What is the first number? First number is 3. That is called as section number 3. So this is subclause. Subclause. How to read this? Section 3, subsection 4, clause 1 and subclause A. This is how you're supposed to read the section numbers, or how we can refer to the section numbers. The first number is called as section, second number is called as subsection, the third one is called as clause, and the last one is called as subclause. This is how we are supposed to read the sections. Okay. For example, I'll write one more for you guys. Let's say it is 4, 3, 1 and A. How to read this? Section 4, subsection 3, clause 1, subclause A. So this is section and this is subsection. This is what? Subsection. And this is what, sir? A clause. And this is what, sir? A subclause. Section 4, subsection 3, clause 1 and subclause A. So these are the basic concepts. What are the basic concepts? What is law? Who makes the law? How it is made? And how to read sections. So if you are thorough with this, we can start with the Indian Contract Act 1872. I hope you guys remember the structure of Indian Contract Act 1872. So 1 to 75 deals with what? General principles of contract. 76 to 123 They are no more part of Indian Contract Act. They were repealed in the year 1930, and a separate law is made called as Sale of Goods Act, which is also part of your syllabus that we will discuss separately. Then we have special contracts, that is section number 124 to 238, that we will discuss in detail. Contract of indemnity, guarantee, bailment, pledge and agency. And then we have section number 239 to 266, which deals with the contract of partnership. Again, these are no more part of Indian Contract Act. They were repealed from the Indian Contract Act, and a separate law was made called as the Partnership Act 1932. So without wasting further time, let's start with the first set of sections, section number 1 to 75, which deals with a basic principles or general principles of Indian Contract Act 1872. So let's start. Section number 1. Remember this, section number 1 in any act, take it Companies Act, Partnership Act, Sale of Goods Act, Negotiable Instrument Act, or IPC, CRPC, section number 1 provides 3 important provisions. What are they, sir? It provides about the short name, short title, the short title of the Indian Contract Act. Every law will have 2 names. One is short title, another one is long title. So like how you guys have the 2 names in your home. So parents call with a short name, right? A nickname. In the same way, law has a long title as well as the short title. Section number 1 provides the short title. It also provides the extent of applicability of the law, to what extent this law is applicable, and it also provides about commencement, means on what date this law came into force. So all the laws, in all the laws, section number 1 provides short title, extent and commencement, and in few cases it may also provide applicability of the law, means to what section of society or to what extent that law is applicable. Okay, the short title of this Indian contract is, it is not the short title is the Indian Contract Act, the Indian Contract Act, 1872. So you should write the act name in the same way which is written here. You should write the Indian Contract Act 1872. Extent, what is the coverage of this act? Sir, is it applicable to the entire India, sir? Yes, there are no exceptions now. Before repealment of Article 370, that is in the year 2019. Before 2019, this law was applicable to entire India except Jammu and Kashmir. But now, because the Article 370 is repealed, all the laws made in the Parliament of India are also applicable to Jammu and Kashmir. It's a union territory now. So there are no special status. There is no special status given to Jammu and Kashmir. Hence, the laws made in the Parliament or all the laws which were in existence are automatically made applicable to whom? Jammu and Kashmir. So the law is applicable to where? The whole of India. No exceptions, no special status, no special provisions. Entire India. It's applicable to entire India. Commencement. The law came into force. Which law? The Indian Contract Act came into force from 1st September 1872. Sir, is it before independence, sir? Obviously it is before independence, because 1947 we got independence. So then why are we following the British law, sir? Because even though this law was made during the British period 1872, and we also have IPC, Indian Penal Code, which deals with our criminal offenses, for example murder, crime, all that are governed by the IPC. And this IPC was made in which year? 1860, 12 years before Indian Contract Act 1872. But we still follow the IPC 1860. Sir, why, sir? Are we following the British law even today, sir? Yes, it is a law made by the British, but these laws were again adopted or passed where in the Indian Parliament. Which Parliament? Indian Parliament. Sir, when, sir? Indian Parliament in the year after 26th of January 1950. So we got the Constitution of India in which year? 26th of January 1950. So after we got Constitution of India, whatever the laws which were in existence and which were still holding good, means which was still serving the purpose, those laws were again adopted or passed in the Indian Parliament, and they become part of our Indian legal system. Become part of what? Indian legal system. So that is why this law, even though it is made in the British period, the law is still applicable and it can be followed by the people. Okay, so it is an Indian law which was made during the British period, 26 Jan 1950. Done? Yes. So section number 1 provides short title, extent, and the commencement. The short title is the Indian Contract Act 1872, extent whole of India, commencement 1st September 1872. This is the commencement of the act. Section number 2, in any law, section number 2 provides what? Provides a definitions. Section number 2, it is also called as interpretation clause. What clause? Interpretation clause. Now what is interpretation clause, sir? Interpretation means the correct understanding of the meaning of the words is called as interpretations. Whenever there is an ambiguity in the words used in the law, or you need to ascertain the meaning of the words used in the law, you can refer to what? Definitions given under section number 2. Section number 2 provides the list of definitions which can be referred to understand the meaning. So in any law, if you want to search the meaning of a particular word, where you can search? Section number 2, which provides the list of definitions. Section number 1, short title, extent, commencement. Section number 2 provides the definitions. Clear? And we will discuss the definitions as and when they are required while discussing the other topics. Now, as we are discussing about the chapter called the Indian Contract Act 1872, let us understand what is a contract. What is a contract? What is contract, or how the contracts are made? Kaisa banta hai contract, like how people enters into a contract. What is the starting step? What is the meaning of this word contracts? So let us discuss this with an equations. See, every contract starts with offer. Starts with an offer or a proposal. So when this offer or a proposal made by one of the party, if it is accepted by another party, offer, when it is accepted, it becomes what? Becomes a promise. Becomes a promise. And when this promise has a considerations, most important, when the promise made by the parties has a consideration, it becomes an agreement. So agreement is the second stage. And once this agreement is enforceable by law, agreement which are enforceable by law, most important, enforceable by law, that is in the court of law, only those kind of agreements are called as contract. So every contract starts with what? An offer or a proposal. Starts with offer by one party, and when that offer is accepted, it becomes a promise, and a promise which has considerations is called agreement, and agreement which is enforceable by law becomes a contract. Sir, let us take an example, sir. With the example we'll understand. Let's say Mr. X want to sell his car. What I want to sell is not car. Let's take it as a house. He want to sell his house. He has a house. So he makes or he communicates something to Mr. Y. He says, Mr. Y, I want to sell. I want to sell. Sell what? Sell my house. At what price? Let's say 1 lakh rupees. And Y is willing to purchase the house of Mr. X. So what he says? He says, yes, I agree to buy. I agree to buy. I agree to buy the house. At what price? 1 lakh rupees. So here X made an offer to sell his house and Y made an he said I will purchase your house. So both made this contract in written form. So this is a contract and this is made on in a written form. It is in writing. It is in the form of a writing. Later what happened? Y paid the money. So this is the second one. Then Y paid the money. Y paid the money. But X is refusing to transfer the house. Refusing to do the mutation. Refusing to sign or refusing to do the execute the transfer deed. A transfer a deed. So Mr. X broke his promise. He made a promise, but he broke his promise. Now the question is, what would be the remedy available to Mr. Y? What is the remedy? What he can do? Mr. X made a promise to transfer his house to Mr. Y. He took the money, but now he is refusing to transfer it to Mr. Y. What Y can do? Y can approach the court and get the legal remedies from the court, provided if there is a valid agreement or valid contract. So let us decide whether there is a valid contract or not. First thing, every contract starts with what? Offer. Correct, right? So is there any valid offer here? The answer is yes. So who made an offer? X made an offer. When he said, I want to sell my house at 1 lakh rupees, it means he made an offer to whom? To Mr. Y. So we have an offer. And when this offer is accepted, so kya hona chahiye? There should be an acceptance. Acceptance. Is there any acceptance? Yes. Offer was made by X and Y gave an acceptance. So offer plus acceptance becomes what? A promise. So now who made a promise, sir? X made a promise to Y. X made a promise to whom? To Y. And who also made a promise? Y made a promise to Mr. X. So there are two promises. What is the promise he made? He made a promise to sell the land. He made a promise to pay the 1 lakh rupees. So there is a promise by both the parties. So offer plus acceptance becomes what? A promise. And this promise are required to have some consideration. Now what is consideration, sir? The word consideration means something in return. Something in return. So something in return is called as what? Consideration. So when there is a consideration for both the parties, it is called as what? Something in return. It is also called as quid pro quo. Quid pro quo in the Latin term. So what is quid pro quo, sir? Means something in return. So for selling his land, what X is getting? Payment of money. There is a promise to pay the money. In the same way, for making the payment of 1 lakh rupees, what is the consideration for Mr. Y? There is a promise to transfer the house. So can we say there is a consideration for both the parties? Yes, there is a consideration for both the parties. So there is a consideration for X as well as Y. So this condition is also satisfied. Agreement is there. So now the question is this agreement enforceable in the court of law? Sir, what is enforceable by law? If it is legally valid, if the court can assist the person to enforce his right in the court, it is called as enforceable by law. We can say that an agreement is enforceable by law if it satisfies the following questions. Okay, so an agreement is enforceable by law if it satisfies what? Satisfy the following conditions. Following conditions. So what are the conditions to be satisfied to be enforceable by law, sir? An agreement to be enforceable by law must satisfy four important conditions. What are they? The fish can laugh at when nighttime. If the fish can laugh at night, then it is enforceable by law. Otherwise, it is not enforceable by law. Sir, when can we say the fish can laugh at night, sir? So what is this fish can laugh at night, sir? What does it mean, sir? It's an acronym. Take the first word, F, C, L, N. So what is F? F means the free consent. What is C? Competent to contract. Competent to contract. What is L? Lawful object and consideration. And what is N? Not expressly declared as void. Declared as void. So all agreements are enforceable by law, means all agreements becomes contract, or they are legally valid, tenable, or recognized by the law, enforced by the court, if it satisfies how many conditions? The fundamental conditions, the four basic conditions. What are they? First thing is there should be free consent, means the party should enter into a contract at the free will. We will discuss later what is free consent in detail. And the party should be competent to contract, means they should have the capacity to enter into a contract, major, sound mind, not disqualified by law. They should also have a lawful object and considerations. The object or the purpose for which they are entering into the contract is should be lawful, and that agreement whichever they are making should not be expressly declared as void by any law. So these are the basic conditions or fundamental conditions to be satisfied to be a what contract? A valid contract. What are the conditions? There should be free consent. Parties must be competent to contract. There should be lawful object and consideration, and the agreement should not be expressly declared as void. Now let us compare these conditions with an example. Was there any free consent? Yes, both made the contract at their own will. Are the parties competent to contract? Yes, both are major, sound mind. Is the object lawful? Yes, selling of land. And is it expressly declared as void by any law? The answer is no. So because it satisfies all the four conditions, the agreement is enforceable by law and it is a contract. So Y can approach, X can approach whom? Y can approach whom? Court, because he has not received the transfer of house. He can approach the court and he can compel, or the court will compel Mr. X to transfer the house or transfer the land or to make a payment of compensations, because it is enforceable by law. This is how the contracts are made. This is the nutshell. In nutshell, we can say this is the entire contract act. That is what we're going to discuss. We're going to discuss in detail what is offer, rules of offer, what is acceptance, rules of acceptance. We're going to discuss what is consideration, rules of consideration. We're going to discuss what are agreement which are enforceable by law, not enforceable by law. Again, we will discuss what is free consent, competent to contract, lawful object, not expressly declared as void. So this is nothing but your entire Contract Act 1872. So we will discuss in detail what is offer, acceptance, consideration, agreement, and which is enforceable by law. So in brief, an agreement becomes contract only if it is enforceable by law. So and contract starts with what? Proposal. Section number 2 subclause A defines the word what? A proposal. Section number 2 subclause B defines the word what? Acceptance. Section number 2 clause C defines the word what? Promise. Section number 2 clause D defines the word what? Consideration. 2 clause E agreement, and 2 clause H contract. If you remember the equation, section numbers becomes easy. 2A offer, 2B acceptance, 2C promise, 2D considerations, 2E agreement, and 2H the contract. And we will discuss in detail later what is offer, what is acceptance, what is promise, what is considerations, and what are agreement and what are contract. So this is how the contracts are made in India. Okay. Yes. We'll discuss the remaining topics in the next class. Next class will be of more number of hours that we will discuss later. Okay. Thank you.